90, right? Yes, Mr. Mahendra. One thing, Mr. Mahendra, see, admittedly now the offense is registered, he will face that criminal case, whatever outcome of the criminal case, it will follow. The point is now, till that time, whether is stopping to him to carry out the activity is in the interest of the government also. Otherwise, finally, whatever the order passed by the criminal court will be binding. If somebody is aggrieved, he will take the matter to a further court.
Offense committed by the petitioner is concerned.
That's a different aspect, no?
As not illegal extraction of minerals outside this area is concerned, he is liable to pay the 15 times of royalty. That is exactly for the reason that we have issued a notice produced at case number 93. But we gave an option to compounding the offense in order to not reopen the buying activity. Thereafter, on 17/10/2022, we issued this notice. Page number 93.
Yes.
Page number 94, the last paragraph. Accordingly, if drone survey report is submitted to this office at the earliest, we not suggested him, since he is not admitting our joint inspection report, let him conduct this
drone survey.
And submit a report to the department.
No, his specific point is that can you stop the quarrying? Under which clause?
Rule, sub-rule 2 of Rule 8. And what I will ask, this is pertinent to mention here. This is the second offense he has committed. On an earlier occasion in the year 2021, he encroached upon 1 acre of land. Thereafter, he imposed 5 lakhs fine. He has paid it. Now he has encroached 3 acres. This is the second offense which attracts 50 times.
Any reference to that earlier encroachment is there in the notice?
The inspection itself is mentioned. Let me kindly come to page number 63, para 8. Previously, Previously, the geologist of this office has submitted spot inspection report on 19/11/2021, and for having conducted mining operation in an area beyond the lease, a sum of rupees 5 lakhs was collected as penalty and the city mine paid. Now, this merger was drawn on 27th May 2022. In presence of the representative of the lessee. And on the same day, a report, joint inspection report was submitted.
But why his representative signature was not obtained?
You have to kindly appreciate it. You have to kindly see. The marker drawn at page number 54 is a spot marker. Translation is produced at page number 57.
Right.
While conducting spot merger, GPS recordings were made. It is evident from the margin. May I read the last portion of the margin? That apart, Hunter is adjoining to the lease area. Reserve is 15 meters. Buffer zone quarry is
That is why it is put in the office.
in the buffer zone of 50 meters and 10
Yes, sir.
areas tracked by GPS.
Why did he not obtain his signature? No. representative is there.
He was very much present.
Right.
And GPS tracking was recorded. And a report was submitted. In the report, all the readings were recorded. This is a report, not joint inspection report. In which the signature of the representative of the petitioner are. And the very important fact is that not he chooses to challenge only annexure E. Thereafter, several notices have been issued. This is dated 66/2022. Thereafter, we have issued 2 notices. One is produced at annexure D, 10th August 22. And thereafter, annexure H, 17th October 22. Now he says, after all this, he has lodged a complaint before the jurisdictional police, stating that there is illegal activity. Whereas this Mahajan was conducted in the month of June itself. In the month of December, after all this, in order to not make out a defense.
So he has challenged annexure E because you asked him to stop the mining. So according to him, unless you determine the lease, you cannot stop the mining lease. Is his point?
Yes. May I take your life?
Yes.
Rule 2 of Rule 8 Act of KM together. Quarrying operation to be in accordance with the quarrying plan, simplified quarrying plan. And state 2. If the quarrying operations are not carried out,
882. 882. We K2.
Yes.
quarrying operations to be in accordance with the quarrying plan, simplified quarrying plan. One plan, every holder of the lease license working for permission and tender carry out quarrying operation in accordance with the approved quarrying plan, simplified quarrying plan, with such conditions. Above permanent. The quarrying plan will be granted to the lease area. If there is a violation of quarrying plan, if he encroaches upon the adjacent area, it is violation of quarrying. Quarrying plan is not granted to that area. But may further, as may have been imposed under the Rule 2 of 280 or with such modification as approved under Rule 3 of 860 in accordance with the quarrying plan, simplified quarrying plan, or the scheme of quarrying submitted or approved under Rule 8 if the quarrying operations are not carried out in accordance with the quarrying plan, simplified quarrying plan, as referred under Rule 1, Deputy Director, Senior Geologist concerned may pass an order for suspension of all or any of the quarrying operations and permit the continuance of only such operation as may be necessary to restore the condition in the quarry as envisaged under the said quarrying plan. If you are violated in the very quarrying plan, so we have issued a stoppage. Thereafter, we have modified it. We informing him, we compound the offense and come back. Then one more notice was conduct a drone survey and submit the bank guarantee to illegally extracted mineral. They permit him. For that, he has not challenged those notices at all. Even otherwise, there is a remedy under 53. He could have gone before the divisional authority.
No, in a revision, he can challenge that stoppage or
If he is agreed by the not second notice annexed head, yeah. No reference to rule 8A. And body plan is a different thing, body is a different thing. There are two different concepts in the Karnataka minor legal constitution.
you have now, are you availing the remedy? Now he says that we have passed the orders, but you have a remedy of challenging these orders in a revision.
Right.
8K2.
8A. 8A2 deals with quarrying plan. There is not even a single word about quarrying plan in any of these annexures which have not even the word in the name, usage of the word quarrying plan in the entire annex. Nowhere. Quarrying plan is a different aspect, and quarrying lease is a different. They are two different documents.
All this you can raise in the revision that you have a particular plan which permits you to carry out your operation within A area, B area.
That's what we asked. In response to your submission, we requested the council to answer. He has pointed out the provision. You said, without terminating the lease, they cannot stop is what your submission in the morning session. They have pointed out now. Now you're saying the word plan is not used.
When we see K1, quarrying plan has been defined. Quarrying lease is different, quarrying plan. There are two different documents. It is not their case nowhere, my lords. For the first time today, at this moment, my lords, my learned friend has put forth this hearing. If this is put in writing, my lords, I can come out.
So they will provide a copy of the book also along with their order. This is expectation is too much, Mr. Khan. And it is acceptable somebody who is coming before this court as a first offender. You are repeating your activity. You were informed that you are indulged in such activity which was found by the authority second time. Inspection report says that prior to this also you committed this act. You paid the penalty. It's not that in the first occasion you challenge it, you accept it, paid the penalty.
In 1 month of granting release, penalty was imposed. 5 lakhs.
Therefore, we are.
Not working in the area. Then what should they have been? They should have earmarked the area. If they did not do. My plan, what my learned friend would submit, my lords. It is not at all their case, my lords, suppose that there is violation of the quarrying plan. Quarrying plan is a different thing, my lords. It's not.
Mr. Counsel, take it that even if it is not so specifically stated, the communication forwarded to you is sufficient enough to show for what purposes these notices, orders are issued to you for encroaching upon the land that is without having the permission to you to carry out the operation within a specified area. You encroach upon the area. You are carrying out the operation not in your specified area, but you are doing that in the other area. This is indicative of a fact that there is this violation of the this provision where you are permitted to carry out activity within an area of a plan. It is not necessary that each and every word is to be reproduced. And apart from that, we also told you that the submission is okay. We have passed these orders. The orders are revised. You can go before the authority, seek a revision of the order.
petition to bring in within the quarrying plan. It's not that we are imposing bank guarantee is part of quarrying plan. 2.5 years is gone by.
Otherwise, he'll go on another issue.
Is that they may raise a ground of delay, will permit you to file appropriate application for the delay condonation, and authority may consider the fact that you were before this court for some time.
3 days.
Hmm.
He's coming at 22nd. 22nd, yes.
It cannot be controlled.
Then why did you keep quiet all these years? Whom are you blaming now? No, this attitude of your client is not correct. You are putting every single blame on the other side while you want to merrily go around doing this illegal act. You know about that, and why did you not go earlier?
No.
Not you, sir. Not you, sir. Not you. We are conscious what we are saying, you are saying on behalf of your client. So whatever we are saying to you, we are telling to your client, not to you.
Provision provides.
Yes.
Provided control as a case will be satisfied sufficient cause for 30 days or from the period of 60 days.
90 days. 90 days.
That opportunity is there. Sorry?
It says that he has power to control. Regional authority, I have no issue.
No, the proviso provides 30 days more.
30 days more from after 60 days.
Yes, so you make an application. We'll say that if such application is made before the authority, authority may consider that on the backdrop of a fact that you are before this court. Yes, Mr. Mahendra.
Beyond 30 days, 60 days.
Well, our madly order. See, whether rightly or wrongly, let the authority pass an order. Why do we prepone that?
When I have asked your lordship to consider my lordship there for the direction to consider my representation as well, is also one of the prayers. That my lordship. Yes, see. Also one of the directions which I saw. If after that I get an opportunity of doing.
We need the cause of action. What are the subsequent notices you have issued for what purpose?
There was a scarcity of land in the district.
No. Once you have stopped the mining, which means he is no more existing in accordance with law to carry out any activity. Why the subsequent notices?
Subsequent notice because of scarcity of land in the district. A district land monitoring committee decided to reopen the suspended quarry.
That's why you are looking for cause of action. These notices are there for you.
Yes. Those notices will not be allowed in the that is also time one.
No. Annexure K. Annexure, kindly come to Annexure K, sir. 1st June 2023.
But this is a notice asking me to put in GPS.
You are in search of some cause of action. No, these notices are there for you.
This has nothing to do with quarrying on that. That's wanted to give you a kind notice that even today, according to them, I'm entitled to. They want me to install GPS equipment in all the vehicles to be used for transportation.
That will help you, no? If the GPS is installed, you can show the material that you are restricting your activity only to the limited area.
Yes, the vehicles quarries. So normally we don't, unless we start the quarry, we don't have these quarries. We are all small villages. What should you direct my consideration of connection here?
L is your representation, no? So we permit you to file appropriate revision.
There is no harm that for him to conduct a drone survey. Drone survey and submit a rank guarantee. That's what that is. Because there is a violation admitted.
Revision is also refused. Which they cannot condone. There's come only one big expenditure.
Only we can say that the
Representation can correctly.
representation L.
That he mandated to submit a drone survey. Why did you conduct a drone survey?
After that, they are asking me to furnish the bank guarantee. Drone survey of my quarry is area.
Bank guarantee for what?
For illegally
Extracting the
Already extracted.
Already.
How much is that?
That is.
Have you quantified it?
5,004.
Correct. After determination, if it is so, we pay.
Cash I recall.
No, Mr. Counsel, it is your case that you have not crossed your limit and you are quarried within your limits. If that proves, then there is no question of they asking you, what's the hurry? Worry in that matter.
Financial mallards, capability. That's one of the consideration. Therefore, even if your lordship directs my lords, let my representation in the connection L be considered in accordance with law. Not asking anything beyond that. In accordance with law, it be considered. Whatever order is passed, my lords, I exhaust my other revenues.
The risk of payment of that penalty will not go.
That depends again, my lords, if suppose I am acquitted.
The choice of you taking the recourse of drone survey and giving the bank guarantee appears to be feasible.
It is not that my lords only today it is done through for a long time by somebody else. They want that for that entire area. You are so financially sound, my lords, you have done by looking for it. Giving bank guarantee is nothing but making a payment. Making payment and giving bank guarantee, there is no much difference.
Don't decide in L. If you are only now restricting your prayer L decision on the representation. Notice to the respondents accepted by learned government advocate Sri Mahendra. Do. The council was heard at length. Ultimately, it was submitted by the council that he would restrict his submissions only in reference to prayer clause C, whereby direction is sought for to respond number 3, that is senior geologist, to decide the representation of petitioner. The copy of the representation is placed on record At page 105, Annexure L, translation is provided at page 106. Accordingly, the petition is disposed of. The learned government advocate submits that if certain reasonable time is granted to the authority to decide the representation, the authority would decide the representation accordingly. The response number 3, Senior Geologist, Department of Mines and Geology, DC Office Complex, Hospet Road, Koppal, is directed to decide representation submitted by the petitioner on 24/7/23 as expeditiously as possible and not later than 8 weeks from the date of receipt of the order of this court. Needless to state that representation be decided on its own merits in case the respondent number 3 is of an opinion to call for necessary record from his subordinate officers. Opportunity of hearing. Deems it appropriate to grant an opportunity of hearing to the petitioner, he may accordingly intimate the petitioner. He may send a prior intimation to the petitioner for hearing the petitioner and pass appropriate orders. This direction, the petition is disposed. There is already one matter mentioned at serial number 62. So we'll take that matter first. Same matter.
Get amount of 17 directly.
Yes. Who appears for the other side? The information stating that about 44 lakh has been transferred to the land acquisition officer to be transferred to the complainant hearing as on 28/7/2011. Is not done. And today we have got the approval for payment of 10 crore. No, why this piecemeal? Your officer is literate. No, whose approval he is waiting for? Then what the officers are facing is that there is some discrepancy. Last time the order Millard, I have told and informed them very clearly. Also mentioned. The officer was also present in the court. But somehow he is facing the problem that is what he mentioned. Whose approval he is waiting for? No, we are not approving this. That today 10, tomorrow 2, day after tomorrow 5. Our order is more than clear. We wanted compliance. Every fact is recorded in our order dated 22/8/23. It was only to submit before this court that we are ready with this amount. No, we are not. It's not that they are showing some extra. They can take the approval if they are state guest. All approvals, all sufficient time to think over.
Worse than a private litigation. Worse than a private litigation.
Even private parties may not show such approach. And to only impress upon, we refer to that the sale deed is between a complainant and the topmost authority of the state. And the person concerned was signatory on behalf of this authority. We don't want your proper affidavit. We want simple one statement that I am ready with this amount by way of demand draft, check, whatever it may be, and I am handing over it to the complainant. No affidavit, a statement, single line statement sufficient enough, showing that you are ready with the amount.
But they are saying that they will deposit in the court that I'm asked to make the submission to your lordship.
Why so auspicious? More auspicious? This is not a court. In which court? What is if they wanted to deposit in court, what they treat to this place as? I mean, this is absurd.
Which court you want to deposit?
This court you want to do.
Why?
But there is a government order that
In what?
deposit in
On what basis? You have to advise them properly, Mr. Kamji. Please advise them properly. There's no dispute of anything whatsoever. Sale is executed by them in favor of the governor of the state. Very clearly mentions about the consideration. That's all you need to pay. Nothing more. It's a registered document. If you do not honor this, who else? What can a common man expect from? No, please look into this. The sale deed, we have referred to the sale deed clauses. 7 crore 74 lakh and all is mentioned the sale deed. That amount merely has to pay to them, that's all. Where is it all coming from? Discrepancy, deposit in the court, government order, approval, 10 crores, 50 lakhs. What is all this? This limit. This is not a borrower or a where pleading financial difficulty, give me installment, I'll make the payment.
why exactly this installment is
Therefore, we made our order very clear. We were sensing that there may be some difficulty, there may be some ground, something in the form of an excuse would be raised. So everything we made it clear as a part of our order. You just go through our orders. You will then you will have a benefit. Keep this on. I didn't check. So we'll give a day's time to you, Mr. Vikram. We'll keep it on Friday. First on board. Simply say so to Friday first on board. It seems that they are just living in some fantasy world. I don't know. I mean, very sorry. See, this is certainly not a very happy situation for a court or to any law officer to face this situation. No, this is something very embarrassing for anybody. But this can be avoided.
Advise them.
When the affidavit is filed? 24.
Before that, it was to see the order passed by this one before the last day. Just to put the affidavit in perspective, the certain appointed very, very interest in the
Yes. Which order you are referring? 9-8. Yes.
There is a right net of there is certain queries were put to the other official application. In reply to the other official will be submit that pursuant to the order passed by the Dallas Civil, even government public safety takes proper initiative for the meeting under the chairmanship that was held a meeting under the chairmanship of the Minister of Primary and Secondary Education on 7/2023 for considering the issue of the recruitment of 2000 graduate primary teachers. Our attention is invited to the statement of objection dated 18/4/2023 filed by the state on behalf of the respondents. Copy of the minutes of the meeting at 7/2/2023 annexed to the statement of objection as annexure R1, where it stated that 22,432 candidates have been qualified as per the checklist for the recruitment of graduate primary. The relevant portion of the minutes of the meeting is discussed. 22,432 candidates are qualified in the published running checklist for the recruitment of graduate primary teachers. The appointment is verified to the government specific candidate, while 1,849 female candidates have mentioned married in their online application and mentioned their husbands in submitting their fathers, mothers, parents' income certificate. Reservation is referred for such candidates, while government order dated 12/12/1986 will not be applicable. In footnote 4 of the minutes of the meeting, a reference is made to the judgment passed by the LSC that is specified. The judgment passed by the Honorable High Court. The state is reserved liberty to regulate its procedure by continuing the recruitment and taking it to its logical conclusion. In said background, the candidates who have approached the Honorable Court, claiming that the father's income certificate has been delivered to the current recruit and not considered even if they have submitted the father's income certificate. The eligible candidates who have submitted the father's or parents' income certificate and the candidates who are submitting the husband's income certificate who are already in the merit will be considered on the basis of overall merit and revised 1:1 million. It has been decided to prepare the selection. On a per-user, these are the questions raised by the court. On a per-user with the minutes of the meeting, we find that there is no sufficient material to justify payment of clause for the resolution. What is the criteria applied to finalizing the number of candidates to extend the 19,400? What would be the exact number of candidates belonging to other categories after applying the resolution? Whether the state government is desirous of taking complete departure from the government order electoral practices, or this departure is only limited to the limited extent of selection of graduate driving. These issues are required to be clarified to the state government as such as the state government directed consultation directive, giving better particulars and details with reference to the aforementioned issues raised by the order. While the learned senior counsel appearing for the appearance advanced the submission of various aspects. One of the alternate submissions is that the state government is in urgent need of appointing 15,000 graduate primary. The appearance who will be out of consideration at the result of the order passed by the learned secretary are in limited numbers and have submitted their claims complying with the necessary formalities. The state government may consider to accommodate these others. Also, the selection process. The state government may also make its stand clear in this regard in the additional act. Honorables, may I request this honorable court to take the affidavit. These queries have been addressed. Paragraph 3 onward. I'll read the affidavit. Wherever necessary, I'll refer to the that will throw light on what is stated. Now, I can see paragraph 3 onward. I state that this one before, while it's already in 9 is for certain information. One amongst them is the method criteria adopted for finalizing the number of candidates to the extent of acts have been considered and adopted for finalizing the number of days to 1. It is submitted in the notification issued on 21/3/2022 for appointment of graduate faculty after the council guidance. 15,000 posts were notified for issues. 5,000 for Kalyan Karnataka districts and 20,000 for other districts. Next R1, which is at page 8 of my affidavit. There is a category-wise reservation number of posts, and the horizontal is the language or the subject for which those posts are rated. Now, can you see language English teacher, GM 346, SC 311, total, I won't total 1,360. Similarly, social studies teacher Urdu, Kannada, Marathi, Kannada medium, Urdu, there are various subjects where vacancies have been notified in the original notification. Now, Manoj also can be that is on the next page. The total vacancies are 15,000. At the right hand corner. For example, 6,681 is general merit, SC 2,555, 577 on 282 degree, and total is 15,000. Totally 4,470.
Yes.
One more aspect of it, come back to page 2. I'll read Roman 2.
Yes.
It is submitted that notification for appointment were issued district-wise, and accordingly, 35 individual notifications were issued by appointing authorities of 35 districts. Now, I just pause here for a moment. These are 35 educational districts. Subject to correction, these are 31 revenue districts. For the educational districts, the state is divided into 35. So for each district, there would have been a separate notification issued, again subject-wise. If all 35 are added together, it comes to 15,000. So therefore, subject-wise, each district, and while it had to be done district-wise, each district had its own number of vacancies in various subjects. So for example, possibly, just to give an example, in Belgaum, there might have been a greater need for Marathi medium teachers, as opposed to someone say in Mysore district or Karnataka. So keeping all of that in mind, individual notifications were issued for all 35 districts. I didn't want to burden the court with all 35 notifications. As a sample, if you also see at page 10, That is for Chipala. At that notification, my Lord will see value reached 97. Put it as illustrated. Just to point out how the process has been conducted. Sorry, this is in Kannada, but only for the limited purpose of how it has been done. If my Lord will see Anubandha 1, which is on page 27, the table below. This is Jilya Hesaru Chikbalapur Jilya, then the notified posts, and Malad kind is Bhashe, English Vishaya Uttagalo, so 23 total. Then Ganita Mata Vignana Vishaya, then Samaja Pratagalo, then Geovik. So for each subject, and also this the language of instruction also is lower. For example, Kannada, all three are Kannada. So presumably for Chikbalapur, there was no need for any Urdu or Marathi medium. So for each district, based on the vacancies, needs of the government schools, 35 different such notifications were issued. Come back to that. Midway through the Roman 2 paragraph, thereafter, the sentence. Thereafter, competitive examinations were conducted throughout the state in all 35 districts on 21st May 2022 and 22nd May 2020. The candidates were required to appear for the examination in the district where they preferred the application. 3 papers were there in comparative examination, which is first paper on general knowledge of 150 marks, second paper on subject content knowledge, and third paper on language for 100. It is submitted at a minimum score of 45% was described in the second paper and 50% in the third paper, which was taken as per the norm for eligibility, irrespective of the category under which the candidate applied for. There were no minimum marks fixed for the first paper, but attendance was compulsory in the subject, and the score was also considered when preparing the merit list. They submit that when preparing the merit list, the weightage of marks is considered as this may not be totally relevant. Skip to paragraph 5. This is important. So it is submitted that out of 1,06,083 applicants, a total number of 67,892 candidates were found eligible for selection in all subjects. Therefore, out of a total of 1,06,083 applicants, only 67,892 what the qualifying marks as prescribed in the notification. In the previous paragraph, I mentioned 45% was the prescribed percent. So the remaining 38,190 were immediately disqualified. So the kindly see the only as reference page 31. Was an aggregate of all the districts put together. The breakup of each of the districts was 2 volumes. So at page 31, annexure R3, along the find the right hand bottom column, totally in all the subjects and all the categories put together, only 67,892 out of 1,06,000 had qualified based on the entrance examination or the qualified exam, passing. We come back to paragraph 6 of the This will answer the question, Your Lordship, about how this 22,432 came. It's submitted that out of 67,892 eligible candidates, 1:2 eligibility list was prepared. And instead of the required 30,000, now that would be logical for 15,000 posts into 2. 1:2, 30,000 whatever required. Only 22,432 candidates were selected on roster and merit basis from all 35 districts. This is because some of the categories did not have twice the required number of candidates. Now, just to give an example, we come back. I'm sorry, going back and forth. Page 32. Page 32 to 37 is a breakup of all the districts. Now, today as a matter of illustration, now we can see the first one, Bangalore law. First, we can see this is what language, English. The first row. First. Total vacancies notified for 12. Ideally, in a 1:2 vacancy, 24 candidates should have been called. Now, number of eligible candidates were totally 47. Now, again, ideally, out of the 47, 24 whatever vacancy. But only 21 were called. Now, I'll explain why. Now, in each of the notifications, as a auditor, there is a notified vacancy under each category. Now, under GM, there will be a notified vacancy, under SC. So, if we take the total number, it will be 15,000. Multiplied by 2, it ought to be 30,000. But What happened was, in each of the categories, they may not have been, in fact, in several cases, they have not been, twice the number of vacancies. So, even though overall we ought to have called 30,000, but in each of the categories, since we had a shortage, so overall we could only call 22,432.
That is because some of this posts were notified posts.
So that is clear as well. So as I was pointing out in the Chikbala, for example. Now, for example, take English language. There may have been 24, I'll just take an example, 25 votes in vacancies, I'm keeping an even number to vacancies. Now, if we had to call for 24 vacancies, 48 people, that should be the overall number. But that 24 would have been broken up into, for example, 10 GM, 5 SC, 5 ST, and let us say 4 2A2, just for simplicity purpose. Now, ideally, we should have got 48 candidates, 24 into 2. But what happened was, let us say in GM, there were 10 notified votes, but only 5 were eligible. So therefore, we could not have called more than the number of people who were eligible. So therefore, there was a shortage.
Because you did not find eligible candidate for the post.
That's it. For the post, for that subject, for in that district.
Which means
in that category.
that will remain vacant
That's it.
for want of eligible candidate.
That's it. So out of, if there were 15,000 notified posts, finally only 22,000.
What is the eligible criteria there? What is the unique eligible criteria which you did not find, even you had 67,892 candidates?
And even though we have 67,800, on merit able to be ranked. Now, when we call 1:2, we can at best, let us say, once there were 15,000, all of them were eligible. Even out of 67,892, we could at best have called only 30,000 if we applied a 1:2 ratio.
Correct.
But we could not have called 30,000 because in each category, we could not fill up all the vacancies for that particular subject in that particular district, because each recruitment is qua subject, qua district, and qua category. So in each, there is a vertical and a horizontal. So the verticals would be, say, the categories, SC, ST, GM, so on. The horizontal would be the subject, and each of them would be qua the district. So therefore, even though in an ideal situation, 30,000 should have been called in a 1:2
So
ratio.
this 67,000 is the entire state.
Entire state. 67,000 past the exam. That's all.
But the district wise, there was still shortfall.
No, not across all the districts, across the entire state, 67,800 and odd got the minimum qualifying percentage.
No, we understand. No, we're trying to understand the next level.
Yes.
You said if it is district level, if you consider,
Yes.
was there a shortfall of eligible candidate district wise also?
No, but not if they might, in fact, in some cases, now just if I also come back to page 32, I just illustrate it by way of example. Like if I also, I'll just point out by way of illustration. Now, in the first row at page 32,
Correct.
the total vacancies 12, 24 would have been 1:2. Number of eligible 47. So actually, there were more than more candidates than actually the 1:2 vacancy. However, the shortfall was of 3 because in each category we could not find the sufficient number of candidates. Now, for example, there may have been more than 1:2 in GM, but less than 1:2 in SC. More than 1:2 in SC, but less than 1:2 in say 2A. So all put together. Now, obviously, once if there is more than 1:2 in GM, we can't slot the GM candidate in one of the other vacancies. Which is why in the first row there is a shortage of around 3. But the other, if I was to see the fourth row from the top, this is an example where we didn't even have enough sufficient number of eligible candidates. The country is Bangalore Law, Kannada Science, fourth from the top. 46 is the total vacancies. 1:2 would have been 92. But the number of eligible candidates from Bangalore Law were only 62. So this is a very dynamic situation. There could be an excess, there could be a shortfall, which is why instead of 30,000, 22,432 were called for the first level of document verification. Now that is where, my lords, this issue at the first, the issue that AWS litigation arose. Now again, my lords, if my lords is very on this, I'll just continue reading the article, possibly throw further light on what I'm trying to explain. Come back to page 3 of that.
Just a minute. They have called number of
The Bangalore North,
Yes, sir. The first one?
yes, you have 12 vacancies.
Yes, sir.
1:2 ought to have been 24. Number of eligible candidates, you had 47, but you called only 21.
That's right.
Can you just explain that?
My lord, kindly come to page 38. So, again, this is slightly longish table. I'll explain this one. Again, the first row, Bangalore North,
Yeah.
subject Hindi. Now, TM, the first category. Vacancies were in fact zero. So there's no question of considering anyone under TM. Next category will be SC. 45 vacancies for selected four. So we found enough candidates to fill up all the 45 vacancies for Bangalore North, English, SC. SC, also again no problem. C1. I'm so sorry. This is the 1:1 list. I'm sorry. I'm jumping. I'm going one ahead. I'm so sorry. No, I'm coming back to what you watched. Now, since it is Malas category wise.
No. Common prudence suggests that you had 12 vacancies, 24 ought to have been called, you had eligible candidate 47. What made you to find shortage of 3 there again?
Now this 47 comprised of GM, SC, ST, 2A, 2D, 3A, 3B, and C1. Now we can only call 1:2 in each of the categories.
That you mentioned. That is
So
in
there,
GM.
even the 47 total eligible. Now those 47 would be spread across all the categories. Now 47 would include GM, would include various categories.
So in each category, you had not find
That's right. We could not find the double of the number of vacant
of that particular category.
of that category. Therefore, overall, there may have been more number of candidates. For that category, we did not find 1:2.
Yes.
Yes. This reading paragraph 6, home 6. Start paragraph 7. Paragraph 7 in the next page above. It's submitted that, for instance, in the case of mathematics and science and biological science, eligible candidates were found to be less than the ordinary at a point. It is a very dynamic situation. More specifically, with respect to mathematics and science and biology, 254 vacancies were notified, But eligible candidates were 280 numbers. Likewise in CC, they are only illustrated. And the list of shortage also is there. Remember, this is again, as I mentioned, paragraph 8. It is submitted that even though in some districts the candidates are more, they cannot be selected in some other districts as the selection is district wise. In other words, an applicant who applied in a particular district and wrote a comparative exam in that district cannot be considered for some other district. That goes without saying. We applied only for say Chikbala, they can be considered only Chikbala.
Request of the petitions are accommodated.
From subject to hearing you further, is there any statement now applying all these? You can accommodate this many number of the candidates.
Address that later. And why it cannot be done without doing violence to those notifications? Because then we are not necessarily. Since it is a district-wise, subject-wise notification. Now, all the vacant posts have already been filled for that particular subject. Now, obviously, an English teacher who has applied in Mysore cannot be accommodated for an Urdu post which may have fallen vacant in, say, Bidar, or vice versa. An Urdu teacher in Urdu.
No, we quite get
teacher
that.
in Bidar.
We quite get that. The eligibility, the question here is for them that if our certificates were considered without changing the 1986 order, we would have stood a chance as their case. If that is considered, in the districts where you have found vacant posts, can they be accommodated there at least?
If they had to be, they already would have been accommodated to be measured. Because this exercise after the 12-26 circular was first applied, which came to be challenged before the learner season. And after applying the learner season, that is all. And this is important because we did not take complete departure of 12-86. We had to take complete departure of 12-86. The persons such as the appellants would not even have been considered. But since the process was already ongoing and we did not want to give rise to further litigation, the decision was taken that we will apply the 12-86 circular as well as the order of the learner signature, which means that the petitioners were also who were outside the fray earlier were then brought back within the fray. And then the exercise was redone. And when that exercise was redone, whoever could be accommodated were already accommodated. Now, this is most important. This entire list today, which is taking before my revolves only around 450.
Any specific instances where you have accommodated the candidate who was under the circular 1986?
In fact, when 12-86 was applied, and then when the learner signature order was passed, the entire exercise was redone. Now, a fresh exercise was done based on the inter-se merit of those candidates, because initially those outside the fray were brought back within the fray, and when that exercise was redone, which is not submitted, and that exercise was redone, 451 candidates only who were originally in the provisional select list earlier of November 2020 were left out. So this list really revolves around 451 only. Now, why am I pressing on that? Since May, the recruitment of 13,500 teachers has been installed for these 451 posts only. And in fact, not anything about the interim order of May 2020. In fact, would have been restricted to those number of posts only, because the remaining 13,000 have nothing at all to do with this litigation. They may have some other issues with regard to Hyderabad, Karnataka, and so on. But this issue is restricted to, and in fact, I stated that in paragraph 11 of our affidavit.
Page 5.
Page 5. It is submitted that on account of the military exercise by applying the circular unit 12-86 and the judgment of the learner single, and by redrawing a fresh list based on the individual merit of the candidates. 451 candidates present in the earlier selection list have not found place in the revised selection list published on 8/3/2020. Therefore, of the total 1:1 candidates who were selected were 13,352. If you were to exclude this 451, 12,901 posts are completely unaffected by the litigation.
Have you made any category of district-wise category of this 451 candidates? Yeah.
Treatment.
Next page.
Yeah, category wise.
451 candidate, they say they will exclude it. Yeah, for this. Give the district wise, those posts, subject to those posts, the rest they can go probability. It's 451 and for this court. Now this 451 posts also been filled?
Yes, sir, by persons such as the petition.
Correct. So in case if there is any issue, it will affect only this 451.
This is across the state.
Across the state, district wise. So you have the details of that.
District wise, you can furnish. Maybe it was necessary to overburden the court, but this overall, all 35 districts put together 455. And they were obviously only being 2 and 2. That is where this really lies.
Hypothetically,
yes,
even if relief has to be granted in favor of the appellants, and these appointments should be subject to this only to the extent of 451 alone. Give us the details of that district-wise details. Can you do that subject to this 451 district-wise? Can go on. It's for how many cases are there in these appeals now?
Point is 151 about point is whether government order of 1986, there is some confusion. 1986 is only reiterated. Original order is of the year 1983. There was no challenge to the power of the next. And he had no jurisdiction to deal with the matter. There are two aspects. One is whether High Court had jurisdiction. Second is, in accordance with the roster that was assigned to him, whether the learned single judge who passed the order had jurisdiction. These two jurisdictions will have to be decided. The question is, last time all these questions came in the background of what will learned submitted from appearing in the smooth that whether the appellants can be accountable. But in the light of that question, whether the appellants can be accountable with this additional offense and all those things, their answer to that is no. If the answer to accommodate the appellant is no, it is not possible, then the matter has to be decided on merits. The question is not whether it is 450 or 150 or 1 crore. The point is whether the order of the single can be sustained, both on the ground of jurisdiction, then on the question of roster, then on the question of what was pleaded and what has been done.
No, that is why we asked Senior Counsel that we asked Additional Advocate General. He was very clear that they have not departed from the circular of 1986 completely. No, please hear us. Correct. Therefore, no, subject to clarification.
There cannot be all communication.
Correct.
There cannot be partial departure.
No, it's not that. No, we'll come to that. No, his submission was that. The other issue is it is 451 candidates who are been left out of the provisional list. 51 or are left out of the provisional list. Their matter, as you rightly submitted, has to be considered on merits.
How much the matter has been heard at such a length?
Correct.
If my lord give me 40 minutes, I will complete my submission. My lord will complete to pass on order. If my governance is high, because of 451, 12,000 are held up. No, not because of 451. Because of the all minutes in the jurisdiction, all this confusion has arisen. Why not we look at that aspect? All that I am saying, there was no challenge to the reservation order of 1283. The first order of the reservation, which introduced the concept of family income, is of the year 1983.
No. If there is a midway path of saving the present selection list,
That they say
correct. No. They are saying, but we are not accepting that as of now. If there is a midway path of accommodating in accordance with law, this 451, without disturbing the present selection list, on merits, as you're pointing out, whether it's a jurisdiction, whether it's your entitlement, can be considered is what we are looking at. It is not that trying to accommodate or to compromise the matter. It's not about that. If that is a possibility. Yes. Correct.
His notification and instruction. I take your this is a position where your lordship
Continue tomorrow. Okay, we'll continue tomorrow.
on illegality. 30,000 posts will go. Illegal salary cannot be put there. It will not take my permission to interrupt. He should not interfere.
We'll hear it now as we were trying to see.
Control 86 is applicable even after the order of the legislature is an incorrect statement to the bench. As Advocate General, he should not make such a statement. It is a reservation policy. It cannot be altered by means of the chief secretary letter. This is a fraud on the constitution.
He has not said that he is going to or altering the policy. He was making.
He cannot go out of the list. It's totally misleading. Some of the they say that we have followed two policies. One policy laid down by fingerprint, one policy of permanent. I am yet to come across a case where the court has applied two policies in one single report.
No, that is why we asked to give the breakup with regard to 1986.
Why is it not? Have your lordship has rightly indicated. I am going to continue with the 12/12/1986.
Correct.
Now there is no answer in the affidavit. If you follow 12/12/86, it is a part of Article 16(4). It is a constitutional benefit. You know, business to recall it, modify it, and the learned there is no prayer to quash it. And your lordships have held prayer to quash the constitutional reservation order, which has to be laid down only with a specific prayer, specific ground. And the para which I read your lordship was, there is no prayer. The learned
one submission. No. Assuming everything the learned counsel for the appellate secretary accept, I will accept it. I'm assuming that this order could accept.
You violate not resistance and ask for sympathy. Which we will not tolerate.
You are not permitting him to complete his statement. You are not permitting, he is not even allowed to make complete his statement. You are entitled to say the statement is not appropriate or not in consonance with the earlier pronouncement. Anyway, okay, let it at least know what statement he is making.
And as such, making a statement, the decision by secretary, not by the government.
ಅವ್ರು ಹೇಳಿ
You can say that statement is wrong, but let us know what statement he makes.
Yes.
What he is saying.
Yes, therefore at least let us know what statement he is making.
We should know what he is saying, so that we can reply.
Right.
All I'm saying is, assuming the learning senior council according to the evidence 100%. Now I am assuming that they are right, that we could never have to departure from 12, 86 or 83 or whatever. Only around 451 posts will get altered if at all. Now, all I'm requesting is, if your lordship could clarify that the remaining 13,000 or 12,000 odd posts, at least let us notify them, because whatever happens in litigation, those posts will go unaffected. Because they are entirely unaffected by this litigation. If your lordship is clarified, if my lordship see the interim order passed on 2nd of May 2020, it says virtually so and so, the selection process shall go on without announcing the result in the elected affair. Now, one way of reading it is, obviously, this honorable court was conscious of the fact that this is revolving small installment. And the selection process shall go on and not announcing the result is with regard to those posts that are for this litigation and not the other posts. Now, as of course, the state does not want to take an extreme stand and notify the other posts because there is an interim order this one. If Malos could clarify that, leaving aside those posts that are the subject matter of this litigation, if the state is permitted to notify those posts, at least eventually, Malos, we're all acting in the interest of the state, the students.
No, last time that is why we asked, even if that is considered, that 68,000 candidates you shortlisted,
Yes, sir.
they were within the radar of 1986 order. ಅಲ್ಲ one ನಿಮಿಷ ಅದು clarify ಮಾಡ್ಕೊಂಡು because we are no we are only looking at is it no with the 68,000
was across the board. Now, if everyone in this room were to write that,
no just to put a caveat again, we are looking at to avoid any potential litigation thereafter, not just for 51.
Completely bought out. That 68,000 was irrespective of category, irrespective of irrespective of the district. Now, those 68,000, 67,800 were those candidates who qualified above 45%. That's all. Irrespective of the category. Now, the remaining can certainly not be considered. There can never be any cause for
And
those
the second and the second 22 and all.
Second one, now that 1:2 merit list was even at that stage, when that 22,432 was drawn up, again there was no issue of applying 1286 or otherwise, because that was done after doing a simple 1:2 checklist. If there were one vacant post, we will call 2 people for that category.
So therefore, if I was a candidate seeking benefit under 1986 order,
Yes.
was I also included in 22,000?
100%. Now at 20,
That's all we wanted to know.
At that next stage, that's where the
That's what we wanted to know.
22,432
That seems to be clear.
13,500. That's where the issue was.
Seems to be clear. Who have been shortlisted, they have not been kept out merely because they don't satisfy the order on a single judge. That's what we wanted to know. That's what they're saying. It is well within that all the parameters.
Giving effect to their prayer, if it is 451, as per the reservation policy, as per the notification, you have been selected, let our appointment also be given effect. That's the position.
What he says, insofar as those 451, where there is some controversy, where there is something which is submitted to court, let the court decide that issue independently. For those,
thousands of applicants who are outside, inside,
no,
by virtue of protocol 86.
how it can't be now be expanded. What he says, those who were before the court, raising certain issues or making out some point, okay, court may consider independently of these 451.
Subject to the result of the appeals, we will work.
That is what we are coming to.
If we had made, let us say, one of the appellants, why not put that we don't teacher, you are teacher in
This is a practical thing, Mr. Counsel. Now, the teacher, just a minute, a teacher is entitled or competent to teach a particular subject in a particular school. Now, if that post for that teacher is not available, one can't thirst, as you likely say, a Urdu teacher to teach Marathi subject. That will have its own. That will have its own.
451 vacancies are there.
Only vacancies may not be a consideration, sir. Vacancy must be considered with the subject and the eligibility. If a person having all prescribed qualification, okay, you can say he is possessing requisite qualification to teach a school where Urdu subject is to be taught. Who knows Urdu? Yes. But somebody who is having a required qualification to teach science can't be thrust in a school to teach Urdu. And that again, that will be the whether such post is available in that district. We can't only consider the number, we'll have to consider the number, qua the subject, qua the district, availability of a post in that district.
These 451 may be a part. If it is 451, our selection is in accordance with the reservation. Our selection is in accordance with the notification. Therefore, if they wanted to apply the new policy, let the 451 make the result. My lord, I have given the two days back a judgment from the latest Supreme Court judgment that any policy beyond notification, any certificate beyond the notification cannot be accepted. Your lordships are doing injustice if these policy is to be accepted in part.
Right. The injustice would be more if we ask a Marathi teacher to teach Urdu subject in a Urdu school. That therefore.
My course are not done, my course are there, my selection is there. Please give effect to this selection.
The issue is on women reservation.
Then we
75% of the applicants are male. How are they getting into this issue?